Good evening, everyone. Happy Cinco de Mayo. And no, it is not Mexico's Independence Day. It is a celebration of the defeat of Napoleon III's army by a small but scrappy Mexican force in the 19th century. A fitting theme as Ukraine holds out against a larger and brutal Russian army in Europe. And as American women do battle against an English jurist from the 17th century. Take a look at this guy. His name is Sir Matthew Hale. He was quite simply a dumpster fire of awful. He was against abortion. He had 2 women executed for practicing witchcraft, an opinion that established a model for the Salem witch trials. He didn't believe in the concept of rape, warning that rape was an easy accusation to make. In fact, the instruction to jurors to be wary of false accusations of rape is known as the Hale warning. And he didn't have much use for charges of marital rape either. In his book, History of the Pleas of the Crown, he wrote, quote, "The husband cannot be guilty of a rape committed by himself upon his lawful wife," meaning that a wife was a man's property and therefore he cannot commit a crime upon her, nor can she refuse her consent. Interestingly, or rather horrifically, Justice Samuel Alito, in the leaked opinion draft that would overturn Roe v. Wade, cites that exact book in his argument to end abortion. While citing Hale as an historical authority, not once, not twice, but 9 times in an approximately 98-page ruling, mathematically, that's like almost once every 10 pages. Hale was one of the people Alito relied upon for one of his most extreme assertions, that, quote, "an unbroken tradition of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. An unbroken tradition from 17th century English common law to the late 20th century? Well, that could apply to almost anything. Contraception, same-sex marriage, interracial marriage, civil rights, integration, women's rights to vote." And while we have been talking about this leak and its implications during this terrible week in America, I've got to say, it's the contempt for me. The utter contempt that Alito's robe-breaking screed showed toward women. The bile-dripping scorn that he showed over the original decision that granted women autonomy and privacy and ownership of their bodies. This hatred of women and the idea that we are no more than wards of our fathers and then of a husband, and then if not, of the state, simply because we are female. That is the unbroken tradition in this country. And make no mistake, they're coming for all of it. This is the conservative, but really the extremist assault that has been in the works for decades. This drive to repeal the 20th century, the century that in their minds warped America by enshrining women's rights and civil rights and starting the drive toward gay rights and non-white immigration. They want it all to go away. And now they have a court that can make it happen. Alito might say that his reasoning was not meant to apply to any other rights besides abortion, but listen to what he said about Roe v. Wade during his confirmation hearing in 2006 and ask yourself if any thinking person should believe him.
Roe versus Wade is an important precedent of the Supreme Court. It was decided in 1973, so it's been on the books for a long time. It has been challenged on a number of occasions, and I discussed those yesterday, and the Supreme Court has reaffirmed the decision, sometimes on the merits, sometimes in Casey, based on stare decisis. And I think that when a decision is challenged and it is reaffirmed, that strengthens its value.
Ah, yes, the magic word, stare decisis. You heard him, calling Roe v. Wade an important precedent of the Supreme Court, and now drafting an opinion rejecting what he once acknowledged as an established precedent. This is not a justice nor a movement to be trusted on their word. Now let's talk about what this means in the real world. In Louisiana, there is a new so-called fetal personhood bill that could make having an abortion grounds to be charged with homicide. The bill recognizes the human personhood of an unborn fetus starting at the moment of fertilization. This means that having, assisting, or performing an abortion would be classified as homicide, even if Roe v. Wade is not overturned. Louisiana lawmakers advanced this bill out of committee on Wednesday. And joining me now is NYU law professor Melissa Murray, who served as a former clerk to then Judge Sonia Sotomayor, and Michelle Goldberg, columnist for the New York Times. Melissa, I want to start with you on this because before we get to the Louisiana law, I want to get back to the contempt thing. Because I am not a lawyer, but I read through what I really read as a screed. I've read Supreme Court decisions before, And usually they're very lawyerly, and you have to really sort of understand the law, and they have all these citations and everything. This read like a screed. And then when I then later discovered the who exactly, and was able to read up a little bit on who Matthew Hale was, I was like, oh my goodness. This guy is channeling one of the most anti-woman, witch-burning, woman-hating figures in all of human history. Your thoughts?
Well, to be fair to Justice Alito, a number of states have championed Sir Matthew Hale over the years. It's been quite recent that many states have repealed their exemption for marital rape. So he lived for quite a long time in the law books of many states, well into the 20th century. But you're exactly right. Show me that you hate women without showing me that you hate women. This opinion is not just absolute, it's absolutist in its objections, its antipathy for abortion, its antipathy for choice, and it's clear contempt for the idea that the decision to become a parent is so fundamental to the person, so fundamentally changes someone's life that it cannot be a decision that is formed under the compulsion of the state. He rejects this entirely. And again, I think makes it clear that the idea of choosing for yourself is just something this court will not tolerate, certainly not now.
And Michelle, the thing that's so wild about this whole originalism thing, which I can recall a lot of Republicans hectoring Ketanji Brown Jackson, Judge Ketanji Brown Jackson, about originalism. If you go back to the original conception of this country, first of all, Melissa and I weren't even people, so forget about us, right? But even women who were white women were considered absolutely the property and ward of their husband to be transferred to their husband. Even any property, women didn't even inherit property. Whatever they had went right to the husband. And an unmarried woman was most likely to be burned as a witch. Most people who were burned as witches were often unmarried or widows, people who were untethered to a man, which is the only thing that grounded even white women in humanity. So if you are an originalist, you essentially want to go back to that original conception of women who, even 50 years after black men were technically given the right to vote, were still denied it, their own wives and daughters. Your thoughts?
I think you're exactly right about what's so chilling about this decision, or one of the things that's so chilling is that if you take this schema seriously, the only rights that are seen as constitutionally legitimate are those that have a deep history in the American Republic. And nobody, except for white men, has rights that have a deep history from the founding of the American Republic. These were all sort of modern achievements, right? These were all, women got the right to vote in the beginning of the 20th century. Many of the other rights that were won were in the middle or the end of the 20th century. And so the idea that because they were not there 200 years ago, 100 years ago, I believe that one of the citations in Alito's opinion goes back to the 13th century. The idea that sort of something is more legitimate because it has been around for hundreds of years just ensures that only the most right-wing conception of human rights will have the force of constitutional law.
Right. And by the way, not even all white men, only white men who own property. If you were not a property owner, you also could not vote in the originalist conception. Let me go back to some of these footnotes, because you've tweeted a lot and talked a lot about, Melissa, about the footnotes, because, Clarence Thomas, who's one of the more ironic figures on the court, because I wonder what's going to happen when they try to come for interracial marriage, because that's going to affect him. But I don't know what he would think, because he too claims this originalist belief system. There was a footnotes that referenced eugenics. This is one of the most common talking points among anti-choice, among forced birth people. And it says here, other amicus briefs, they present arguments about the motives of proponents of liberal access to abortion. They note that some such supporters have been motivated by a desire to suppress the size of the African-American population. This has been the guise of caring about black people version of arguing against abortion. They'll also sometimes try to talk about the woman who was sort of the progenitor of Planned Parenthood. They try this all the time. He did it in his screed. Your thoughts?
Yeah, so that footnote is actually really interesting. I've written a Harvard Law Review article about the whole eugenics argument, which really has its genesis in a concurring opinion that Justice Thomas filed in a shadow docket case from 2019. It didn't get any takers on the court at that point, but it really had a flourishing life in the lower federal courts when many of Justice Thomas's former clerks, who are now judges, cited it liberally. And the idea is that the disproportionate incidence of abortion among Black women is part, or the vestiges of, this larger campaign by the birth control movement and the eugenicist movement to cite birth control clinics in Black neighborhoods for the purpose of stamping out Black reproduction and limiting Black political power. Now, Justice Thomas, I think it's a very canny move. It's essentially reframing the social meaning of abortion from being an issue of women's equality and gender justice to being a question of racial genocide and racial injustice. But the thing is, you don't actually need to cite it in this opinion. I had argued that it could be a way to overrule Roe versus Wade by saying that this was basically an act of racial injustice. And we've overruled many cases in the past in order to remedy those racial injustices. But that's not the case here. Justice Alito is focusing on Roe versus Wade's untethering of constitutional texts and its lack of deep roots in the history of the United States. He doesn't need to do this. So why is it there? And I think it is at once gratuitous, but also lending sort of a groundwork for what is to come. I mean, this idea that we are changing the social meaning of abortion, that we are casting this as eugenics, and that we are laying the stage for the surveillance of women of color, of minority communities in all aspects of their intimate lives.